Welcome back to the Meadowtown Lessons, where we focus on the development of the individual person as well as their business. Real estate from the inside out. We're pleased to have Mark Weisleder with us to chat about different aspects of real estate transactions, specifically about what happens when things go wrong. This episode is filled with great advice, tips, and strategies to help make real estate transactions go smoothly.
So we're very pleased to have Mark Weisleder with us this morning, prominent GTA lawyer, very well versed in real estate. So when things go wrong, a little tricky getting set up this morning, but just make sure your phones are turned to vibrate. And for the next hour and a half or so, we're going to learn about parts of the real estate industry, doing deals, et cetera, that are going to be important to you. Mark, welcome.
Thank you. So how many of you have heard me speak before? Okay, so I've got a lot of different little topics to talk about today. And so I think you'll find them interesting. I'm going to give you a preview of my Realtor Quest presentation. Are any of you coming to Realtor Quest? So I'm speaking, I have a topic. I'm going to give you a little preview of it today just to get your reaction. But otherwise, feel free to pick up your hand and ask questions as I go through. We don't have to wait till the end. We'll have time. I'll have time to answer all of your questions. And I've been doing this for 34 years now. I've written books. I've been on television a lot with respect to recent changes in residential tenancies, and we will be talking about residential tenancies and the new government lease today as well. I've written columns. If you saw my column this month, I wrote about whether you need to disclose murders or suicides. How many of you saw that column? And so a recent case finally came out, and surprisingly, maybe not to most real estate lawyers, you do not have to disclose whether there is a suicide or murder on the property. However, you're going to have to discuss this in advance with the seller, particularly what happens if somebody asks you whether there has been a suicide or murder. How you are going to answer that question becomes very important. And so, another topic. Read the article, and it'll assist you. What I found very interesting in the article is, as you know, buyers accept patent defects. Patent defects mean you walk into a house and the window is cracked. So if the buyer sees a cracked window, they can't complain about that on closing. The judge said, if you can Google the property address and a murder shows up, that's the same as a cracked window. How many of you Google the property address? Well, there's a lesson for you. And it's interesting that the buyer agent in that case is currently the firm. One of the members of that firm is Korea's president right now. And I saw him because I was speaking in Saskatoon just as this case came out. And he told me, as the buyer brokerage, they were nervous because they didn't do a Google search and that they were going to be blamed. Because had they done a Google search, they would have found out about the murder right away. And so it worked out well for the buyer under different reasons in that case, but it was a very interesting decision. So if you're not doing it, Google search. Okay. And I'm with realestateLawyers.ca. How many of you have sent a deal to real estate lawyers to me at the firm? Okay, so the real question is why the rest of you have not sent me business. No, and I say that really, and sometimes I like to do my own research, so I'll explain. These are the books I have, and I brought a few with me today. Also, my new landlord guide I have with me. It's only $20, and it has the new government lease, plus all the clauses you can insert into the government lease that are legal as a schedule. So, our firm. 90% of our clients, we go to the house to sign the papers. I can't explain to you enough how convenient that is. 90% choose. They could come to sign with me. It's not that they don't like me, but they prefer that we come to their home. So we come, so they don't miss work in the evenings up till midnight and on weekends. We're driving. So you can imagine during the recent cold spell we had in the GTA, how many clients appreciated the fact that we go to them to sign the paperwork. And it's fast. We have all the paperwork on an iPad, so the person signs everybody on an iPad, and then they email them all the paperwork, and then they email everything back to the office. That's how quickly we can process a transaction. Now, And that's the main thing. And it's all included in our prices. Our prices are on the sheet I gave you, and they're very competitive anyways. But we also have 35 offices. But most of those offices are used for key pickups so that our buyers can go to a convenient place to pick up keys for closing. It's funny that the sellers who we sell to, their buyers don't have the problem of having to pick up keys because we give a lockbox to every one of our sellers and they leave the keys in the lockbox. We just give the buyer lawyer the code and their client goes right to the house after closing and lets themselves in. How many of you think that's a good solution? Yeah, I wish more seller lawyers would do that for my buyers. And we let them keep the lockbox because it's cheaper for a lockbox than to courier keys to the buyer lawyer so that the buyer has to go there to pick up the keys. So that's how we do it. Now, I don't know if any of you have ever closed a real estate deal by yourself. We're everywhere. So I can close deals up in Muskoka, Ottawa, London, Barrie, and the entire GTA. So it doesn't matter where your client is, we go to the client home.
So if you're representing the buyer, not the seller, they have to go to one of these sections?
Yeah, well, you know, we do what's best for the client. It may be best for the client to pick the keys up here. If they say, you know what, I live right beside the realtor office, we'll arrange for the keys to be picked up here. So we will arrange whatever is good for the clients, but we have all those offices to choose from as well. Now, if you've ever closed a real estate deal, it's typically a panic where the client or you has to go to a bank, get a bank draft or a certified check and go running to the lawyer's office on the day of closing or the day before closing. Make it simple. We do not accept bank drafts or certified checks. Instead, what we did is we opened up a trust account at every bank. So I think we're the only firm that has a trust account at every bank. So what that means is it doesn't matter where the client banks, TD, CIBC, Royal Bank, they just go to the bank and do a transfer from their account to my account. It's free. Doesn't cost them anything. And all they do is get a picture receipt. They email the receipt to the clerk working on the file, and the money's already in my account and we close the deal, and the money's guaranteed. And it's wonderful that way. And so it's very simple for the client to transfer money. And when it comes to the seller, we pay the seller the same way, electronically. So that way, you see, if you put a certified check into a seller's account, even if it's a lawyer's check, the bank will hold it for 10 days. The same way your brokerage will hold a certified check. With us, it's an immediate transfer. That means there's no hold, and the seller has the money like this. How many of you think that would matter to a seller? That matters to a seller. And by the way, that's how we pay commission. We deposit your commission electronically. You never have to come looking for a check. It goes right into the commission trust account. And that's how we do it. And so here's something that we do, and I don't know if other firms do. The minute the deal closes, whether it's noon, 2 o'clock, 4 o'clock, the client gets an email saying, congratulations with all the closing documents. That means the mortgage, the deed, everything that's registered goes right out to them literally 2 minutes after registration. The next email, because we don't want the agent having all the documents, but the next email goes to the agent saying, please be advised your deal has closed. How many of you would like to know that automatically on the day of closing without having to call? You never have to call, because that's number one for our people. Let the agent know the deal closed as soon as it closed. So you never have to call. If it's going past 5 o'clock, it's because there could be a problem with the funds. We don't have the money from the buyer lawyers, so it's dragging out to 5 o'clock, et cetera. So if you haven't heard, there's a reason for it. And finally, that makes me available. So before I came here this morning, I had to review already 3 status certificates so that people could make offers on condominiums tonight without a condition. And I don't charge for that. We don't charge for any of that because, and frankly, I don't need the client to promise that he's going to use me for the deal. I know they're going to use me for the deal. I do this as a favor for the agent. So the agent can say to the client, I can get your status certificate reviewed before a bidding war, and it doesn't cost you anything. And so that's what we do. That's what I do, and I'm also available to help. So I'll come back to if you may have relationships with other lawyers, I get it, but if you have a client in a retirement home, they can't get to a lawyer, remember, we'll go to the retirement home to sign them up. That's what we do. We go to hospitals to sign up. I had a very unfortunate situation where during the course of a deal, the person, it didn't look like they were going to make it, and we literally sent somebody to the hospital to sign them up. They didn't make it, but we were able to close the deal because we got the paper signed before they passed away. We didn't have to go to probate, didn't have to do anything, got the deal closed. So we're equipped to do that very quickly at our firm. Okay, so when buyers cannot close, that's where we're going to start. So when a buyer cannot close, the deposit has to stay in your trust account until there's a mutual release. You know this. Until a mutual release is signed, money has to stay in your account. So what happens typically? The seller, if they don't settle, can resell the property and sue for the difference in price. So if the price was $500,000 and $20,000 deposit, and then the house resold for $450,000, the seller can sue for the $20,000 deposit plus another $30,000 to get back all their money. So that's typically what happens when a buyer cannot close. Now, interestingly, if the seller sells it for more than $500,000, they can still sue for the deposit. So even if they sold for a profit, they're entitled to the deposit because when you pay a deposit, you are essentially promising to close the deal. You didn't close the deal, you forfeit the deposit as well. Yes?
Can you give an approximate length of time that it takes to get that suing process?
Well, you see, it also depends how much money's involved. If a deposit, for example, or the damages are under $25,000, small claims court takes about 18 months to get to trial. If it's a higher amount, then you're into the court process. So depending on how smart the defense lawyers are, it could be 3 years. And this is what people have to understand before they sue. So when they come to me for advice, I explain the legal process so that they understand. So for you as a listing brokerage, when a buyer can't close, you can't relist the property until you get a letter from the seller lawyer that says the buyer has breached, put the house back on the market. You see, you can't say we need a mutual release because if you get a mutual release, the seller can't sue the buyer. So you're not going to have a mutual release, but you're going to need a letter from the seller lawyer saying the buyer's in breach, put it on the market again. What happens when sellers refuse to close? So when sellers, same thing, the money has to stay in your trust account. This was happening at the beginning of 2017. I noticed that sellers were trying to get out of deals. Why? They signed in October of 2016. The market went up 15%, and it was just greed, greed, greed. They tried to get out of deal. So what happens when that happens? It's a little bit more complicated because the buyer, if they sign a release to get the deposit, they can't sue the seller. So that's a bit of a problem for a buyer. So a buyer has two choices. They can sue for something called specific performance. So specific performance means, same example, the buyers agreed to buy a house for $500,000, sellers refused to close. So the buyer can take the seller to court and say to a judge, force that seller to sell me the house for $500,000. That's what specific performance is. Or they can buy a similar property and sue for the difference. So if they paid $500 and it'll cost them $550 to buy a different property today, they could buy that and sue for $50,000. So if you were the buyer, or let's say you're the lawyer giving advice, which option would you recommend to the buyer? Sue for the house, $500, what you paid for it, or buy another property for $550 and sue for the difference? How many would say buy another property and sue for the difference? Yes, and that's what I will typically advise, even though the buyer says it's not fair, because it's not easy to prove specific performance. You almost have to prove to a judge that you could not find a similar property. And remember, that lawsuit could take 3 years. And this is, if I'm speaking to buyers, I'm saying 3 years, where are your kids going to go to school for 3 years? And if you're out of the market and you lose, you can't buy a house. So because I try to take all those things in consideration, if a seller refuses to close, buyers, I typically try to get them to buy another property and sue for the difference. It's an easier lawsuit to establish, close, and finish. Yes?
Then wouldn't they have to come up with another deposit while they're current?
Yeah, very interesting. Good point. And actually, when this happened to me in a couple of instances, I actually made a deal with the seller lawyer without any prejudice. Let us take the deposit that's being held. You don't want it anyways. Let us use it to buy another house. Because that way, we're not signing a release, but at least we're reducing our damages. I've actually been able to make that deal with a seller lawyer without actually signing a release, because they understand it as well. Okay, good question. But because it's hard to prove specific performance and 3 years to sue, et cetera, you have to think about that when you're a buyer or seller. In all lawsuits, they have to think about that. Okay, so now are you entitled to commission? So let's talk about this. The buyer cannot close. So if the buyer cannot close, the listing brokerage cannot claim any commission because, the seller wants a deal that can close. However, the buyer brokerage could sue for commission if you had a signed BRA, because you did your job. If you're a buyer brokerage, you found them a house, they couldn't close. So you're entitled to commission. How many of you would sue for that commission? No. How many of you would sue for that? Like, I'm telling you, you're entitled to it, but you better be very careful if you sue for that commission. And I'll just tell you one example this past summer. As you know, deals were falling apart this summer. So there was one deal, I think it was 1.2 million. And of course, the buyers couldn't get their financing because the prices dropped, and they couldn't sell their own home because their prices dropped. They ended up walking away, I think it was $100,000. So they just walked away from the $100,000, and then the buyer brokerage sued them for commission, 2.5% of 1.2 million. How do you think social media reacted when they heard that a buyer brokerage was suing these people who had to walk away from $100,000? Do you understand? That case hasn't even gotten close to court, and already they were smearing. So you have to think about that. I'm really against suing for a lot of reasons because of something like this. Social media changes the game when it comes to lawsuits. So yes, but a buyer brokerage could sue for commission. Now, if the seller refuses to close, as you know, the listing brokerage could sue for commission. And every seller that has come to me saying that I want to get out of this deal, that's the first thing I tell them. You still owe the commission because the listing brokerage did their job. And so that's a different kind of lawsuit to consider, right? If a seller's cheating you out of commission by refusing to close, I'm not so sure on social media it would be treated the same way. But you're definitely entitled to commission if that happens. If the buyer and seller only sign a mutual release, so let's say you don't sign a mutual release, but the buyer and seller sign a mutual release, then you can only sue for commission if you don't sign the mutual release. So you see, if a buyer and seller come to you with a mutual release and you think as a listing brokerage you might be able to sue for commission, then you can't sign the mutual release, because if you sign the mutual release, you can't sue for commission. My advice is to sign the mutual release, because then you stop the parties from suing you or taking you to RICO or all the other stuff. So I'm a big believer in signing up with the mutual release. So even though you don't have to sign a mutual release, you must release the money. So if the two people say, pay the money to the buyer, pay the money to the seller, whatever they tell you, you must follow. Whether you sign the mutual release or not, you have to transfer the money. Does that make sense? Okay, are there any questions about this? Yes?
What if the deposit check doesn't come in after the agreement is signed and accepted?
So the deposit check is not paid. In other words, the buyer has changed their mind after they sign the acceptance. So that's a good question. So let's say, same thing, $500,000 offer is signed and accepted, and it said the deposit is payable within 24 hours, and that check doesn't come in because the buyer has buyer's remorse. That is the same as breaching the contract. So what that means is that the seller could sue the buyer for the difference in price. So the buyer doesn't pay the deposit, so the lawyer says, you're in breach, we're going to put the property back on the market, and if there's a lower price, we're going to sue you for the difference. And the seller, if they can find the buyer, could sue them. But you also have to take that into account. Are they going to be able to find the buyer? And who is the buyer? See, that's another thing. A lot of buyers come in and they're students buying for parents overseas. They have nothing. So if that buyer who has nothing stops the deposit, what are you going to sue? So you see, lawyers will look at that too. Who are you going to sue? How are you going to serve? But the simple answer to your question is, by refusing to pay the deposit, you could be sued. Now, a buyer called me once. Many times they call me and say, we have buyer's remorse. We don't want to go through with the deal. Should we pay the deposit? So I say to them, either way, you're going to get sued. But you're less likely to be sued if you don't pay the deposit, because now the seller has nothing. They have no security, and unless they know where you work and who you are, and if you have another house, you're probably better off not paying the deposit. But you can still be sued. But you understand that? You understand that? So they can still be sued, but I think they're in a little better position if there's no money on the table. Because now the seller is like, ugh. And in that case, where I told the buyer not to pay the deposit, it was like a $3 million deal, $250,000 deposit. It was a big deal. The seller ended up asking for a mutual release in order to sign with another buyer. So they got out completely. And I believe had they paid the deposit, they never would have let them out. Yes?
So we're talking about a situation where the deposit has not been received?
Yes.
So then, does that not mean that if there's no consideration?
No. The consideration is the agreement to purchase. You could have an offer with no deposit, everything due on closing. Consideration is just the purchase price for the property. And the deposit is just how it's going to be paid. In some communities, they pay $100 as a deposit.
So if it's signed under seal, then it's a contract.
Yeah, with the seal and everything, it's a contract. It was a contract when it was signed. And the consideration is not the deposit. It's the purchase price, $500 for the property. The deposit just says how we're paying the $500. Okay, very good. It's good that you're asking me these questions. Okay, so should people settle? It's always better to settle. As a lawyer, I always look for the way to settle this, because otherwise nobody gets paid. And what good is that? And so we got to try to settle it. So let me give you some ideas. So what I will usually say to the seller is, if the market has changed, this buyer is probably still the best deal you're going to have on the table. Let's look at it and try to save the deal. So extensions, and I'm going to talk about extensions a little bit more this morning, but that's the first method. What are the terms of the extension? Can we extend the deal in a way and get it closed without too much financial hardship? Take back mortgages. So in some cases, the vendor may want to give the buyer some money for a year to help them make the difference up to close the deal. The problem with that practically is many lenders to buyers will not allow a second mortgage back on a property. So you see, it's a term of most mortgages that there's no secondary financing. So there are some lenders that don't care, but some that do. So unless the buyer has maybe some other security, other property they can give as security to the seller, the BTB is a possibility. Reduction in the purchase price. So on some deals, you ask for a reduction in the price. And again, it depends on who the buyer is. So I had one where I just blatantly said to the seller, we cannot get a mortgage, but give us $100,000 discount, we'll close the deal. And of course they scream and yell, and yeah, I understand. But the fact is, you're not going to get another offer that's $100,000 less. It'll be more. And I said, my client's a student, and he has no money. So if you want to sue, go ahead. You understand? And so there, I had a little bit of leverage. Now, if the buyer was a millionaire with properties, the seller's going to say, to hell with you. I'm not going to let you off 1 cent. So it depends. Sometimes a reduction still makes the deal happen. I've been doing this a little bit too, putting the property back on the market without a release. So what I did with this one is, buyer put in an offer recently at $630 with a $40,000 deposit, which was a big deposit. Had buyer's remorse right away and wanted to get out of the deal. The lawyer said to me, and I felt very bad. You know, she complained about being pressured. It didn't matter. I'm acting for the seller. So I said, why don't we do this? We'll put the property back on the market without a release. And we're going to have a contract between the two of us. And I said, if an offer comes in from anywhere that results in a loss not greater than $25,000, we can accept it without your permission. And the deposit, we'll get the 25 and you get the 15 and we walk away. And then if it's a bigger loss, and I had it up to 40, I said, you're going to give us the cell phone and email of the buyer and the buyer lawyer, and we're going to give you 6 hours to either close with us at the price or accept the loss up to $40,000. And we'll give you 6 hours. And that way, we could still tell the buyer, to leave it open for 6, 7, 8 hours, which is not normal. So PS, we were able to get an offer in that resulted in a loss of about $28,000. And I said to the seller, just take it and eat the $3,000 yourself so we don't have any fights. You'll get 25, but the buyer will get 15, and that's exactly what happened. And so the deal is now firm, and the seller's getting part of the deposit. The buyer doesn't have a lawsuit, and they're walking away. But in that case, and the listing brokerage signed the mutual release because the listing brokerage got the commission on the other deal. Does the buyer potentially still owe the buyer brokerage commission on this for not closing? They could. You understand? And I said to the other lawyer, I'm not waiting for a release from your buyer brokerage because they may not give it. They may want commission because they did their job. They found the buyer property and the buyer's walking away. So I said, we'll do this. I'm not getting a release. And they were confident that if the buyer brokerage sues, they could counterclaim with something. But does that sound like a good solution? Yeah, so you see, one thing I knew was that you can't put the property back on the market and say it's subject to mutual releases on previous deals because no buyer's going to put in an offer when they see that kind of stuff. So this is the way we did it, and we were able to get the deal done. And this just happened last week. So the market is still a little bit volatile right now. Okay, so, yes?
Can I just circle back to that? And correct me if I'm wrong, but it almost sounds like you're saying that the deposit isn't a guaranteed loss if somebody doesn't close. Is that right?
The deposit, when you say it's lost, it's held in a brokerage trust account until somebody sues and a judge says in 3 years you're entitled to the deposit. So it's not lost.
But a buyer may get it back, is what you're saying. It isn't necessary that they...
No, if they refuse to close, it's very difficult to win that lawsuit. They would have to find a good reason of misrepresentation. Do you understand? It's going to be very hard. Also, buyers who have no money anymore can't find lawyers who are going to act for them either. Which also brings us to our next subject, which is very important, which is when they try to blame you for their predicament. So either the buyer or the seller is blaming you for this. So in this case, the buyer was saying their agent pushed them, browbeat them, made them put in an offer without conditions, right? All the stuff that they always do when there's a bidding war. And the seller lawyer, if it's the alternate and they don't want to close, oh, he didn't tell me all the offers that were out there. They always try to blame you. You're the easiest one to blame. So that's why you have insurance. And most lawsuits against agents say that you were negligent. How many of you understand sort of what negligent means? How many of you think it's bad? It's not bad. It's not. You know what's bad? Fraud. That's bad. Fraud is bad. You could lose your license for fraud. You don't lose any license for negligence. So don't ever think negligence is bad. I'm going to explain to you what negligence is. You made an honest mistake. Somebody was depending on it, and they suffered a loss. That's negligence. And so you can see, it's not hard, because how many of you would agree that the only person the buyer or seller interacts with normally, from the time they start the process till they sign the contract, is you? So you see, it's easy for them to say they're depending on you. And if they lose any money, even if you made an honest mistake, that's negligence, because they're depending on you. So you see, negligence is not a bad thing. I want you to understand that. It's not a bad thing. Somebody accuses you of it, just remember, this is not a bad thing. So you're not covered for fraud. So if you commit fraud in a deal, you're not covered by your insurance company. So as soon as somebody calls you, and you already know these calls where somebody's blaming you for their predicament. Oh, I can't get a mortgage, you should have warned me, even though you warned them. Can't get them. So as soon as you think that blame is coming, you should already go talk to your manager here and say, I think the client's going to try to blame me for their problems. Maybe we should be contacting the insurance company. That's it. Your insurance premium doesn't go up when you call the insurance company and say, I think this person is going to blame me for something. I don't know. And then they will usually say, don't speak to them anymore, get them to write whatever they need from you, and then send it to us. That typically is the process. So you have to get in the habit of saying that, is we better go speak to the insurance company. And you got to be very careful what to say, because when somebody says you screwed up, it really does hurt. You're a professional. And so you have to know what to say. So you cannot admit liability. And so what would be an example? I should have known that. You can never say that to a client or another lawyer because they're trying to trap you into admitting you did something wrong. And worse, if you said something like this, you're not covered by your insurance policy because they don't cover you if you admit liability. So you're not going to, you know what you're going to think? When somebody blames you for something, my voice should be in the back of your head saying this: it's not your fault. It's not your fault. Even if it is your fault, it's not your fault. You tell yourself that over and over again. And I'll explain why in a minute. Also, try not to just offer a large gift to make the problem go away, because that's almost like admitting liability. So you see, so what are you going to say to somebody when they tell you this? So words matter. This is what I would say, typically. I understand you're upset because you can't get a mortgage. I understand you're upset. You can't get a mortgage. Or whatever it is. Demonstrate you listened, and then say, I'm going to have to get back to you about that. That's your answer. And then you go talk to your manager, talk to the insurance company, and that's it. And that way you will never have a problem with your insurance. These things, this could be the best lesson you'll remember today, is just say that if this ever happens to you. Okay, so buying, selling, avoiding closing issues. Where possible, do not have a client buy and sell on the same day. Because especially today, Friday, 27th, there's a lot of deals closing today. And when somebody, let me just tell you what they're doing. They're packing up their house. They're already finished packing by 10 in the morning, and they're already driving with the moving truck over to the new house, and they're already calling the lawyer's office, where's my key? And the lawyer's office, and it doesn't matter which lawyer's office, is saying to them, I told you I can't get you the key until your sale closes and we close your purchase. You knew this. Well, when's that going to happen? I told you. It could be anywhere 3 to 5 p.m. Do you know how much I got to pay the movers? I told you this when I asked you if you didn't want to change from both deals on the same day. But this is what happens. So that's part of it. And then let's say their buyer needs an extension till Monday. Why? Because their financing's late, whatever. They're still on that truck. I can't close their purchase because I don't have the money from the sale. They have to go to a hotel, store all that furniture, and hopefully we get an extension on all of this, and then you got to figure out who's paying for all of these costs, and sometimes it's not so simple, and that's what happens. Last Labor Day, a brokerage called me that one buyer could not close, 5 deals didn't close on the Friday before Labor Day because everybody was waiting for the money. So 5 deals. Real estate lawyers call that a train wreck. That's a real estate train wreck. So how do you avoid that? Well, I got up there bridge financing. People always complain, oh, it's going to cost me money. It doesn't cost any money. The moving costs you save by being able to move in at one time without having to wait 4 hours, that pays for the bridge financing. So I always say close 2 or 3 days early your purchase. You get all the money. And as a lawyer, all we do is we promise the bank that when the sale happens in 3 days, we'll pay you back. And that's it. So if possible, always do bridge financing and your clients will be much happier. That's how we do it. But sometimes it can't be helped. You just do the best you can. I had a 75-year-old woman. She was selling her home to buy a condominium. She was downsizing. Nobody would give her any money. She needed the money from the sale to close her condominium. I remember that file. I called the lawyer for the buyer. 2 weeks before closing, I said, we're closing a purchase on the same day. She's 75 years old. I need the money. Does your client have a mortgage? He said, yes, they have a mortgage. And I remember to call him 2 days before closing. Do you remember me? I need the money. He said, I have the mortgage, don't worry. And then I got busy. It was the Friday before the long weekend. My clerk called me at 5 p.m. Mark, the buyer lawyer needs an extension till Tuesday. And I said, this woman is going to have a heart attack. Do you understand? She's 75. I can't call this person. So I said, so I had to call the seller lawyer to arrange an extension. So I arranged the extension, and then I'm sitting there at my desk, I've got to call this person now. P.S., my clerk calls me back 15 minutes later. Mark, yeah, she's in the condominium. I said, how could she be in the condominium? We didn't give her keys. He said, no, she got to the concierge. She said, I'm here. And they let her in. She's in. So I still remember what I said to the clerk. We did not have this conversation. I left already. I left. I'm at home. I'm at home. You couldn't get hold of me. It's Sabbath, that kind of stuff. You can't call me. And just tell her not to talk to anybody over the weekend because we can't give her any keys. She was smarter than everybody. She was smarter than everybody. We closed the deal Tuesday morning. Nobody knew anything. Nobody knew anything happened. Sellers had already left. They didn't know what happened. Please don't tell your clients to do what I just said. Okay? But that was great. So, these are some tips to avoid problems this summer. Number one, minimum 5% deposit. In over 30 years, if you get 5% as a deposit, they close. So that's a lesson. And I have limit closing to 60 days. When you limit closing time periods, there's much less chance for markets to fluctuate, like when you do 120 days. So try to keep your closing dates to 60 days, if possible. And, learn more, ask more questions about the buyer. Where's the money? It's almost like you're doing FinTrack for the other side. That's the most important thing for FinTrack now. Where's the money coming from? That's what FinTrack wants to know. Where's the money coming from? Okay, just so you know, on the FinTrack form, the receipt of funds, you have to ask the client every time, where's the money coming from? And really, you should ask them for proof that the money came from their account, because a bank draft could come from any account. Do you understand? A bank draft may not be their money. And the FinTrack folks say, you should be getting proof the money came from their account. Now, as of right now, you can't ask clients for that proof, but there are brokerages that are saying, we want something that shows your bank account at the bank, where the money came from. Clients have asked me, do I have to give that to the brokerage? I say no, but I explain why they need it. It's enough if you put on the receipt of funds, client confirmed, money came from their account. I would do that on every receipt of funds. If this brokerage ever gets audited, that's what you should say, because that is number one for FinTrack. Where did the money come from? Yes?
What if it was a gift, not from there?
Well, if it's a gift, there's nothing wrong with a gift. There's nothing wrong with a gift, but if it comes from the parent's account, you're supposed to identify the parents. You know this. So this is why you have to ask the question. And also, on the identification form, where it's got Section B, third parties, you always have to ask the question, are you doing the deal for somebody else? And they say no, and put the X in no. You've got to put that in every form. Are you doing the deal for somebody else? Because that's another high instance of fraud. Okay?
What if the parents are gifting $100,000 to a first-time home buyer? Is that the same situation?
I don't see the problem. There's nothing unusual about parents helping out children to buy a home. That's a good answer. It's the guy who doesn't have a job and he's picking up a property every year. That's a problem. Do you understand? That's a problem. But that's why it's important. You understand where FinTrack is coming from. Okay. Yes.
I try to advocate bridge financing where possible. We've come across some instances lately where that's not possible, say a divorce situation.
Not possible to do what?
To get bridge loaning when it's a divorce situation. So what do you recommend as an alternative? Is there an alternative?
Very good, very good. So when you say a divorce, but they're selling and buying and they need the money to buy another property on the same day, is it that kind of thing?
Yeah, when one party's going.
So all I can say to you there is think about the train wreck. Okay, and then when you're talking to your buyer who is ever buying from this divorced couple, make sure about their circumstance. Like say, are you selling to buy on the same day? No, we're a first-time buyer. Because if they're a first-time buyer, the money's going to be there. You know, they'll have the mortgage. You understand? But if they're selling to buy, then they could have a problem on that side. Then with your seller, ask the same questions. Do you need my money to buy another property the same day? No, they've already sold. You know, or they've already moved out. So then you know for yourself, if worse came to worse, I could get an extension of my sale, and it looks like my buyer's going to be able to close because they're not selling. So you can do that at least to try to help to make sure the deal will close. Because you're right, sometimes there is no way to avoid buying and selling on the same day. And, you know, I listened to a Law Society program recently. Please make sure in every offer you put in that money can be paid by, you know how it says certified check, bank draft, or the large value transaction. Please leave that, make sure that is in every offer. Because that allows me, as a buyer lawyer, to press a button and move the money right into the seller lawyer's trust account. Because I have trust accounts at every bank, we have until 6 o'clock to get the money into the other lawyer's trust account. Now, the registry office system closes at 5, but it doesn't matter. As long as I get the money into the seller lawyer's account before 6, the deal closes. So in this kind of situation where they're selling and buying on the same day, we already have the money ready to go to the seller lawyer. It just is a button. It's ready. But we have to see the money come in from the buyer lawyer. Like, if we don't see the money come in, we can't send it. So I've actually had some deals where the money came in at 10 to 6. We were able to press the button and close the deal before 6 o'clock. But for the firms that just deal with certified checks, that's impossible. Because you can't do a certified check without the money, then you put it in a courier. Imagine when the weather is bad. Just do a favor to your clients, put in large value transaction system. This allows firms like mine to just wire money all over the province, and it's instantaneous closing with the other firms. Okay, also, you may want to do the title search in advance, and I'm going to show you how to do that a little bit later in the program. Okay, so when you're thinking of an extension, sometimes the buyer will come to you for an extension before it really gets to the lawyers. I want to show you what lawyers think about when a buyer asks for an extension. So, because it's not just putting insert or delete April 30th, insert June 30th. That's not enough for an extension. So the first thing we will ask for when deals are going bad is we want another non-refundable deposit. So an additional deposit, whatever's there. We want more money. You want an extension. My seller needs to know you really intend to close. We need an additional deposit, but it's not going into anybody's trust account. It's going right to the seller. So non-refundable means it's going right to the seller. But it's still going to be applied to the purchase price. It's not a penalty. It's just an additional deposit that's going right to the seller. Now, sometimes buyers, they don't have the money. And the lawyer will say, we don't have the money. And so in that situation, what I've been able to sometimes get a term is that whatever the deposit is that's at the listing brokerage trust account, we just have it released to the seller. So now you see the seller would not have to sue for that deposit if the buyer couldn't close. And so as a brokerage, you would have no choice. You would have to give that money to the seller if the buyer and seller say, give the deposit to the seller. So that is a term that a lot of lawyers insist on for an extension. Because again, it takes away the requirement to sue, and it's sort of like it motivates the seller to accept the extension, because now they have the deposit. Was there a question? Yes.
How do you phrase this letter?
It's really, you would say, it's that language that says the parties agree to sign a irrevocable direction to the brokerage to release the deposit of $40,000 to the seller without the necessity of a mutual release. So that's the kind of language that would have to be there. The lawyers, that's typically what we say. Okay, now you have to talk about interest. Okay, in my example that I gave you, it was $500,000 with a $20,000 deposit. So let's say there's no additional deposit. There's still $480,000 that's not being paid today. So the seller should earn interest on that money. I put 4% here. Some lawyers try to get more of a percent. It depends on the negotiating position. But you see, though, that the seller should be compensated, especially if they're bridge financing themselves and they're paying the bank sometimes prime +3 for bridge financing. Now they can't pay that back. So sometimes this interest goes higher depending on the situation of the seller. And there are standard extension terms that say that no more extensions. And the last one here, that the adjustments would remain as the original closing date. So just to understand, you see, if we were closing April 30th, it means that the seller would be responsible for 1/3 of the year's property taxes, and the buyer would be responsible for 2/3. But if we extend it to the end of June, normally, now the seller's responsible for 1/2 the taxes, and the buyer's responsible for 1/2. When we say the adjustments stay April 30th, it means that even if we're closing June, the seller's only responsible for 1/3 of the property taxes. So these are terms that we typically will negotiate, and I wanted you to be aware of them in case you are asked to do an extension. So you understand what the lawyers are going through, and you should think about that too as well. Okay, so now I wanted to explain how to do a title search or what to learn. It's my feeling that if you were able to do a title search before you went on a listing presentation, you would actually have a better shot at winning the listing than if you didn't. And that's really the topic of my course at Realtor Quest. So I've just got a few slides here to show you. You're welcome to come. It's the end of May, but I'm going to show it to you now. So when you get into Geo Warehouse, you're going to look for this slide or this screen, and you see what it says store. This is where you're going to go enter, and you're going to buy the parcel. The parcel is the title. And it costs between $30 and $40. That's what I have to pay to do a title search. And just so you know, anybody can go onto anybody's title in Ontario and pay for the search and see what they paid for the property. Anybody can do that. But they pay for it. And that really is the whole point of this, Competition Bureau thing. Realtors wouldn't mind if people paid for the information. You paid. It's giving it for free that bothers people. But that's a different argument. So you buy the title search, and you will see this is a blow-up of the top of the page. This is a blow-up. So what can we learn right away from the top of the page? So you'll see where the arrow's pointing. That is the correct spelling of the names of the owner or name on title. That goes on your listing. So if somebody changed their name for whatever reason, you use the red arrow. That's how it's on title. That's how it's going to be transferred. It's much simpler. If they have a different name now, the lawyers will fix that, but that's what should go on your listing. Over here, under capacity, it'll say either joint tenants or tenants in common. And so that becomes important if one of your parties has passed away. So let's say you have two names here, and it says joint tenants here. And you know that one of them has passed away, but they're still both shown on impact. Your listing only goes in the survivor's name. That's how you do the listing. And title does not have to be changed literally until the closing date. So on closing, as long as I have a death certificate of the person who passed away, I can register a transfer first to the survivor, and then from the survivor to the buyer. That's how we do it. But your listing is just in the name of the survivor. Up here, you see it says fee simple absolute. There's another kind of title called conversion qualified. Those are two different kinds of land titles. Absolute, conversion qualified. And this I will go into a little bit more at Realtor Quest, but just as a short form, if it says absolute, you cannot steal any property by possession. So this is very important for all these boundary disputes. You can't steal. Whatever the survey says, it is. But if it says conversion qualified, it is possible to still steal land. It's not easy, but it's possible. I'll explain how at Realtor Quest. So that's the first thing. The second thing that flows from this is if somebody has passed away, and then the question is, do you need probate for the estate to sell? And I'll get into this more at Realtor Quest, but if it says absolute, you must get probate. There's no way around it. If it says conversion qualified, then it is possible to sell the land without probate. It would take me about 3 minutes to look at title and tell you this, and you'll be able to as well if you come to Realtor Quest. So that is just the words, fee simple absolute over there, that's what tells you that story. And you could save the estate thousands of dollars if this doesn't have to go into probate. Mortgages. So if you buy the page, I don't know if you can see this, this says charge $250,000 the Toronto Dominion Bank. So right away, looking at this page, you can start doing mortgage verification. You might see 2 mortgages. You might see 3 mortgages. That will give you an idea about the situation financially of the seller. You can't just assume that $250,000 is the principal. They may have paid it down. Some of it could be a line of credit that is not used, but it's still going to give you a very good idea about the title. In some cases, you might actually see that there's an old mortgage that was never properly discharged. That's going to be a problem for closing. If you show this to the seller and say, you know, I noticed there's an old mortgage on here, they'll call their lawyer right away because it takes a while to fix that. You could be doing them a big favor by just finding that. And it's easy. You'll just see the word charge that precedes their ownership. Liens. So it's tax time Monday, unfortunately. If you don't pay your taxes, the government now is getting a little bit more aggressive registering liens against your property. And so if you see that tax lien, you got to see who did it. This says the Minister of National Revenue. So you know that this seller owes money for income tax, but you don't know how much. But one thing you do know is that lien has to get paid with the mortgage before you get any commission. So it's another kind of verification before you even meet the person. If I'm the lawyer for the seller, I've got to write a letter to CRA. First, I got to get authorization from the seller to get the amount so that I can pay them on the closing date, because I got to pay them on the closing date. That's one of the things seller lawyers have to do when this shows up. Question?
Is there anything like this, let's say somebody hasn't filed their taxes for the last 5 or 7 years, would there show up a lien?
First of all, remember, the government has to know you own the property. They can't just register it everywhere they go. It's hard to say what it could be related to. It just, you know that money's owing. Trust me, the seller knows how much they owe. Okay. Now this is a little bit blow up of the top line legal description. So under the first slide, there was a legal description. Let's see what it says. It says Lot 18, Plan 4323, ST, SC114591. What does ST stand for? Very good, subject to. So is subject to a good thing or a bad thing for a property? What do you think? How many think it's a good thing to have an ST? How many of you think it's not such a good thing? Yeah, subject to means somebody else has the right to come onto part of this property to do something. That's what it means. So that's what it means. It's an easement. So now, in this example, this number is usually found somewhere below the page. And it likely says something like Bell Telephone Company of Canada. So what does that mean? Bell has the right to come on the property to fix the wires. Most buyers understand this. And in Clause 10 of the agreement, it says they accept minor easements, which would cover this. So that would cover this. But sometimes it's a larger easement. And a larger easement that could cover 20% of the property is not accepted by the buyer, and they can get out of the deal. And so I recently acted for somebody who bought a house on the ravine on Chaplin in Toronto. How many are familiar with Chaplin Crescent in Toronto, on the ravine side? So they were during their home inspection period, they said, we see an ST, could you check it out for us? And so it costs maybe $5, $3 to get a copy of the instrument. And so I got a copy of the instrument, and it showed that the back 10 feet on all the lots fronting the ravine is reserved for a City of Toronto sewer easement. So I told him, that's what it is. There's a sewer easement on the 10 feet. He said, I want to build a shed behind there at the back. I said, well, you can build it, but, you know, they can make you tear it down. And he said, but my neighbor has a shed back there. Same thing. It's a city easement. They can make you tear it down. Now, do you think it was important for the buyer to know that? It might sort of influence how much money he spends on that shed. But you see, if it was a swimming pool he wanted to build, he would not be able to build a swimming pool because that 10 feet would likely stop him from getting a permit to build his pool. So how many of you think that's important information to know? So as a listing agent, you want to make sure that this ST shows up in your listing agreement. And I've seen that on lots of properties. I see ST something. So ST something, you've already disclosed to the buyer the easement, and they can't get out of the deal. I had a lawyer call me from another city saying, I just have this file. The buyer's trying to get out of the deal because of a fairly large easement. And they're really using it as an excuse because they don't have the money to close. And the first thing I asked her was, does it have an ST in the legal description? Because then there's disclosure and they can't get out. She said it wasn't there. You understand? It wasn't there, so it wasn't disclosed, and the buyer could use this to get out of the deal. So as a listing agent, you want to see this because you want to put it in the listing. You want to put it right in the legal description in the offer. But as a buyer agent now, what do you have to be thinking when you see STs? You have to be thinking, what the hell is this? What the hell is this? Finally, notices. So notices right away should say, oh, notice. My experience, most notices are furnace rental contracts because the companies are getting more aggressive now. When they sign these buyers up to these 10-year contracts, they put something on title. And so you'll see right away that there's some money owing, and right away you should know that this is one of the biggest problems real estate lawyers face today, because even if you put in that the buyer will assume the contract, if the company doesn't agree, that money has to be paid on closing, that whole $10,000. That's how those contracts are worded in the fine print. And so that's why it's so important. And this way you would know it right away. Before you walk into the person's house, the seller, I see you have a furnace rental on title. Do you have a copy of the contract? I want to call the company. I want to make sure that this can be assumed by the buyer so we can put it properly in the contract, et cetera. If you see a CPL, this means the property is under litigation for whatever reason. Could be a spouse suing a spouse, could be a former buyer suing for the property. This is not getting sold if this is on title. So, this was all I wanted to show you today to give you a little bit of a taste. How many of you think this would be good information to know before you went on a listing? How many of you think that you come off as a much different agent on a listing? I know the rest of your presentation is great, whatever it is, your testimonials and all the other wonderful things you have. That's great. But is this a differentiator, you think? Now you're going in there and you're helping this person. You're protecting this person and you're protecting yourself. You make sure there's enough money to close the deal. So that is the reason I'm doing this session at Realtor Quest. You're welcome to come. I'm doing it one time on the 30th, twice on the 31st in the morning if you're there. I think you just show up. I don't know if you can register in advance. Are there any questions about searching a title? Yes?
Yeah, so here's something that the owner of the property died, and there's no, she's not entitled to anything. She's going to be going to court, or she's going to have the bank put a lien on her or give her X amount of days to sell the property. What name would that go into? Like you were saying, the name would be in the survivor's name, correct?
It's hard for me to understand what you're referring to. I mean, you know, because all I know is whenever people start talking about liens, then that means lawyers, and that means all the money goes to lawyers, and nobody can sell it for anything. So that's the guide. Don't waste a lot of time on those kinds of properties. I wanted to leave the rest of the time to residential because I wanted to explain what's going on with the new government lease. Is that okay? Okay. So that's where we're going to change topics now. So, as you know, the new lease form has been released. How many of you have seen it, the new lease form? It's actually quite straightforward. It's not that complicated. I spoke to 500 private landlords, and each one of them said they despised the new government lease. Why? 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 Yes?
It's a lot of pages. It's a lot of pages.
It's not. It's actually very short. When you look at the sections, it's really short. Why do they hate it?
Because it spells out what the tenant can and cannot do.
Yes. In other words, missing all of their lovely illegal clauses. That's why they hate it. Example, tenant agrees to pay $100 for every NSF check. Not legal, it's only $20. Tenant agrees to pay the first $100 of every repair. Not legal. Landlord has to pay for repairs unless the tenant damages. Do you understand? So this is why they hated it, but when I was finished explaining it to them, they actually liked it. But you'll see it's not going to be so easy for you. So let me explain what it is. So you're supposed to, every deal signed after April 30th, you're supposed to use the new government lease. So let's say you signed the lease last year, and now it's going to renew month to month after May 1st. You do not need to use the government lease. You can just continue month to month under the old lease. There's nothing new that you have to do. Now, offered a lease 400. This is the AREA form. I'm not sure it is widely in circulation yet. So what does your offered a lease say today? It says, the parties will sign a lease, and if they don't sign a lease, this is the lease. Correct? Well, that's not legal anymore based on this. So the AREA form will say, I already saw what it's supposed to say. This is what it's going to say, that the seller or the landlord will prepare the new lease using the terms of the offered lease, and the tenant landlord will sign this before the tenant moves in. So you see, now we have this ridiculous two-step process where they're saying, first do an offer to lease, get it accepted, then do a lease. Do you understand? Before you let the tenant in. So it's sort of stupid. So eventually, I think people are going to realize maybe we should just fill out the lease, give it to the landlord and say, here it is. And maybe a cover sheet will just say, this is open for acceptance till midnight. Do you understand? Sign the acceptance, sign the government lease, and you're done. So that's how I see this, to avoid two steps. Okay. Now, let's say you have a private landlord who just signs their regular illegal lease on May 1st. Or you use the old Form 400 where you just signed it and you never did a new lease. The tenant, if in writing they say, I want the new lease, you have 21 days to give them the new lease, or they can hold back 1 month's rent. That's sort of the penalty if you don't give them the lease. Yes?
Duncan and I were reviewing the new Form 400, and in that it does say that the landlord is going to do this. So the question came up, who's going to do this? So are we going to do offer the lease and then have to do the lease and then...
Well, the landlord would likely be looking to you to do this. Yes, they would, but I'm not finished. If after the tenant holds back the rent, you still don't give them the new lease, then they can cancel the lease on 60 days' notice. So no matter what they signed. So first of all, before I take a question, I want you to understand that when I spoke to all these private landlords, one of them said to me, you mean we can use our lease with all its wonderful little clauses, and unless the tenant asks us for this new lease, we're good. I said, yeah. They were so happy. But we don't know how long it'll take for tenants to realize they can ask for this. Do you understand? But the lease still has to be legal. And what I tried to explain to the landlord, using your clauses doesn't make them legal, but you can still do it. So that you have to remember. Yes, you had a question.
Can we use the government form and just do a one-step, lease is done?
That's what I tried to say. I think that more people will just do that.
But can we do that? Because it's not an ARIA form.
It's a government form, we sign our commission agreements, our confirmations, it's
Separate.
things.
Yeah. I think that eventually you're going to have a little process that everybody follows that's easy. But again, a lot of the landlord agents are not going to understand any of this because they're not up to speed. So in the short term, you may just say, maybe let's just use the old Form 400 that doesn't require this. And if the tenant asks, we'll just tell our client, if the tenant in writing asks you for the new lease, you got to give them the new lease.
So the new Form 400 as of March 2018, Clause 12, talks about what you're talking about and makes reference to the new Residential Tenancy Act. Was to prevent you from using 400 and then attaching the government lease, including a clause that, it's part and parcel of this offer of the lease. It's done. Landlord, it's up to you. You want to pay us another half a month's rent to fill it all out for you, and that's what we were talking about. Like, how far do you go on half a month's rent with credit check, application, negotiating the lease? And
Yeah.
look what's happening in the market today.
Yeah, it may be enough to just say, this is the document, you got to go, fill it out, give it to the tenant.
But what's the purpose of doing the 400 if the government lease is already there? Like, why would we bother doing that?
Yeah, I seem to think, why not just fill out the Form 4? When you look at the Form 4, when you look at the new government lease, it's not that complicated. You put in the rent, you put in the utilities, and what else do you put in? That's the question. Okay, so you can put in extra clauses. So I have in my landlord guide about 4 or 5 pages of extra clauses to put in, but here is my no smoking clause. And so my no smoking clause specifically says that there is no cigarette, marijuana, tobacco, or electronic cigarette that can be smoked, and then no tenant can grow any marijuana or cannabis plant. Now, the law's changing, as we know, but there's nothing stopping you from putting this in a lease. And it will be, I know that there's a lot of lobbying going on about, the dangers and should the government stop people in high rises or condominiums from doing this, but it'll be easier to evict if this clause is in the lease. It'll be easier to challenge somebody who says, I must smoke medical marijuana. Well, then why did you agree to this? This is a better argument if it's in the lease. And so this is allowed. It's in my standard terms because it's allowed. It's not illegal. No pets is illegal. Only a condominium that has no pets are you allowed. People always ask me that, Mark, how do I? The tenant lies, they say they don't have a pet, and then they come in with 2 big dogs, and there's nothing I can do. What can I do? I said, get your 7-year-old to help you. What can my 7-year-old do? Tell them to check Facebook. If they got a dog, there'll be a picture of them with the dog on Facebook. Trust me. Just have your 7-year-old go searching, and they'll figure it out. But there's a lesson why you don't qualify tenants, and you don't do this yourself because it's hard. Then you're responsible for all of this. But this is what really good property managers do. They check social media, they check, because if they know this is going to matter for a landlord. Now you're going to have another problem. Oh, must have missed it. I apologize. Thought it was in here. I have a first and last month's rent clause as well. It's in my standard form. Did I give it to you?
Yes.
Okay, I gave it to you, but I didn't put it up on here. So you see you have it here. I'll just read it. Because as you know, the form says you can only ask for what last month's rent. How do you pay HST if you're only holding last month's rent? So what I put here is a deposit equal to 2 months' rent. This is in my standard form, is due at the time of acceptance of this lease by the landlord to be applied to the first and last month's rent due under the lease. So that way you can get the first and last month's rent paid in at one time, and you can pay the commission and plus the HST out of that amount. So that will help you to deal with the government form that says that. I'm only going to give you a warning now about upfront rent, because a lot of tenants are offering a year's rent in advance. The law says that a landlord cannot request more than the first and last month's rent in advance. But if the tenant offers it, it's legal. The problem is, what does offer mean? If a tenant goes to the board and said, yeah, I offered it, but the landlord said if I didn't offer it, I wasn't going to get it, they could still order the money paid back. And so all I can say is you cannot have any text or email that even suggests that they pay upfront rent. If it is a bidding war and you get one offer with upfront rent, it's easy to justify and say it was a bidding war and they offered it and you'll win on that one. I would also tell you to look at who the tenant is. If the tenant is a foreign student, in my experience, they're not looking to cause trouble. They just want to pay the rent and be left alone. So you have to also think about who is the tenant. And is there a possibility they can cause trouble later by going to the board saying you made them offer that 1 year's rent in advance. So be very careful about that. So the maximum rent increase is 1.8%. And this is why there is wars going on between landlords and tenants. Landlords trying to evict tenants because they're paying under market rent and they can only raise it 1.8%. It's also a problem selling a property because if the tenant is there, you can't stage it, you can't do open houses, the place looks like a mess. And there's no real legal way to evict the tenant in those circumstances. So we do have the family reason, and the family reason is the current war between landlords and tenants. So the law is you got to give 60 days notice, and you have to wait till the end of the lease. So if your tenant has a lease till December of this year, you cannot put your kid in there until December of this year. Now they changed the law last September. You have to pay 1 month rent as compensation to the tenant on top of that. So besides giving the tenant 60 days notice, you got to pay them 1 month rent compensation if you're using this family reason, meaning you're putting your kid, yourself, your parents into the unit. Your family member, if it's the kid, has to stay there at least 12 months. So let's say we gave the notice today, it would take effect June 30th, 60 days, end of month. Your kid would have to stay there until June 30th, 2019. If they did not, the penalty is $25,000. Yes.
This is after the lease is over.
Yes.
You can't do anything during the lease period.
No. So let's say your tenant's lease ends December 31st.
Yeah.
You could put your kid in December 31st.
Yeah.
If you give notice 60 days before December 31st, and the kid would have to stay there till December 31st next year.
And you have to pay 1 month.
And pay the 1 month penalty. So if they lied and they really were just going to fix the place up and re-renting, the penalty is $25,000. And also they made another change to the law that a corporation that owns a condominium cannot have a family. So it used to be that if you were a corporation and you owned a condominium, the major shareholder could give the notice for the family and move back in. That's no longer the law. They changed that as well last September. Yes?
Maximum rent increase, so the tenant leaves.
Then you can raise it as much as you want.
Okay.
If the tenant leaves voluntarily, you can raise the rent as much as you want.
Okay, so I buy a place that had a tenant.
We're going to come to that now, because this gets a little bit more complicated. But do you understand now the family reason? Are there any questions about the family? Just so you know, this is not easy to win, because every tenant now comes to the board and says they're lying. They're not really putting a family member in. They're tricking me into leaving. So you have to have a really good faith proof. Like if you're downtown Toronto, your kid's going to Ryerson, they just got accepted, they need the condominium. You have to have proof that sounds good faith that you need this place, because no tenant is walking away. They are challenging this reason. Yes?
On the assumption that you have a fantastic tenant that doesn't want the 1 month, I'm fine, you are great friends. Can both parties agree?
No.
His bylaw?
Well, he can agree not to take it,
Yes.
but he can always come back to you and change his mind,
Even with written notice?
even after it. You can't agree to anything that goes against the act. Yes?
The lease naturally expires December 31st this year. What rights do you have as the landlord versus the tenant? Does the tenant have ongoing rights after the?
Yeah, the lease automatically continues month to month, and the tenant can stay forever until the landlord has a legitimate reason to terminate. So if there's no legitimate reason, the tenant's paying the rent, you don't need it for your family, that tenant can stay, yes.
So saying the penalty is 25,000, how can the old tenant find out that their family stay there for just?
Tenants, you'd be surprised, tenants watch. They watch. They watch. They watch. They watch. The reason I was on BNN about 3 weeks ago, there's another reason for termination called the substantial renovation reason. So in substantial renovation, the rule is you have to give the tenant 4 months' notice, you got to pay them 3 months' rent, and they have the right to come back when you're finished the renovation at the same rent. So this is why landlords don't do this. But there was a smart guy down in Kensington Market who gave the 120-day notice to 8 people who were each paying $1,000 a month rent. And the building was falling apart. He gave this 2 years ago. Each of the tenants said, we want to come back. And they gave the notices, we want to come back. So what he did, finished up all the units and re-rented them to 8 people, each $4,000 a month, put them in, and then when the other people came back, I'm sorry, they're all rented. So they went to the board. And although this case is still ongoing, the judge said, I can't kick out those 8 people. We don't have rights as a landlord board to kick out 8 tenants. And so everybody's called this a renoviction. And all the politicians said, oh, this is a trick, trap, every landlord's going to do this. So they asked me to come down to BNN to talk about it. So I had to go down to 299 Queen Street. Oh, everybody's so good looking in that building, So I go in and I say, so I'm here for my interview. So they said, well, first you have to go to makeup. So I go to makeup and they said, what do I do now? Now you go wait. Okay, so I go wait in the waiting room and then the host, Greg, I don't know if you've seen him on BNN. So he comes out, introduces himself. Hi, I'm Mark. How are you? He goes, have you been to makeup yet? I go, oh. Yeah, that was a good day. Okay, but it was a fun day. But what I basically said was that, number one, they don't need to change the laws. What I didn't want to say is the penalty for corporations is not $25,000, it's $100,000. This is 8 units. That corporation could be fined $800,000 because this was clearly bad faith. Do you understand? So I don't know how that's going to shake out. All I said was the next time a landlord comes to court with this renovation reason, you can bet that every judge there is going to put so many terms on it to prevent this from happening again. You understand? Just like the upfront rent. Once there's a bad decision, they figure it out, how to stop others. Now, the better answer would have been just pay everybody to go away. This is what I tell everybody. Just pay people to go away. But the price goes higher. It goes higher. And so really the best way to get rid of a tenant, find them another place to live. That's what I'm telling you. Before you list, work with the tenant, find them another place to live. That's the best way to have to deal with. But now let's say we have to deal with it today. So you got a buyer and you have a tenant. Let's say you're selling a condo with a tenant. So there's 2 buyers who could be out there. There could be a buyer that says, I like this tenant, I like the rent, I'll take over the lease. That's easy. You just do the sale, the buyer assumes the tenant, you're done. But now you could have a situation where the buyer says, no, I want to move into the unit. Okay, so the same rules apply. If the buyer wants to move in, you got to give notice to the tenant. How long does the buyer have to stay there? 12 months, you understand, or else there's penalties. And you see, the penalty would be to the seller because the seller has to give this notice. So here I've given you a clause if you're going to do this kind of deal, but the interesting thing is there's no penalty here. So there's no 1-month compensation you have to pay to the tenant with this reason. So let's say you have a buyer who says, I'm moving into the unit on closing. So this is the clause. Yeah, I know, but I'll take you through it so you understand what it means. And it takes into account the process, because I understand the process. So the buyer agrees that they or their immediate family intends to move into the property on closing, because you have to have that. Otherwise, if they wanted to rent it to somebody else, you can't agree because now you're tricking the tenant. Then it says the seller agrees to provide the 60-day notice using the N12 on behalf of the buyer. So you see, it's the same as the family notice, 60 days, but you see there's different reasons. So one reason says, my kid is moving in. The other reason says, the buyer is moving in. Do you understand? So it's the same notice, just a different reason. Then it says the buyer agrees to provide whatever support may be required to demonstrate the buyer will be in good faith moving into the property and to indemnify the seller for any damages the seller suffers if the buyer does not remain for at least 1 year after closing. So you see, we try to cover that. Then I go on to say that the deal is going to be extended 30 days if the tenant disputes the claim. And after that, if you still can't get rid of the tenant, then the buyer has the option, unfortunately, to either accept the tenant or cancel the deal, because most buyers can't close if they can't get the tenant out. So let's say you have this clause. I put this into 3 deals last summer, and I explained it to the agents. So let's say the notice had to be served today, April 27. So if we were doing the closing date, I would say, okay, the closing date, let's do July 5th. And we're going to give the notice for June 30th. It's a tight time frame, but that's what we're going to do. Then I said to the agents on each case, I would say to you on May 10th, May 15th, go have a discussion with the tenant and see if they're leaving. So in one of the 3, the agent went in and the tenant said, I found another place, I'm leaving. And so we knew we were going to be able to close at the end of June, and the deal closed. The other 2, I'm not going. This is bull, and to hell with you. So we knew. They didn't believe it, and they weren't going. So right away, I got a good paralegal that I use, and I said, we have to take this tenant to the tribunal before closing. And it takes 30 days to get a date there for a hearing. That's why we have to know in advance. If it was a July 31st termination date, I might wait a little bit longer. But here, the paralegal got a hearing date of June the 10th. Who has to come to the hearing? The buyer has to come. And the buyer has proof. Look, I gave notice. I have to move. July 5th. I got to move. I gave notice in my place. I have a mortgage. The seller says, look, we have an agreement of purchase and sale. I'm selling. This is a legitimate buyer who is moving in. The tenant shows up. They're all lying. In both cases, the judge believed the buyer and the seller. They had all the paperwork. And it was good faith. And so the judge said, I order that the tenancy will terminate June 30th. We can't terminate before June 30th because the notice is June 30th. But now we had a court order that says it terminates. So what I said to the tenant then is, you have to leave. But what happens if the tenant doesn't leave on June 30th? You have to go to the sheriff, because only a sheriff can actually physically remove. And in my experience, that takes about 25 days. Costs $450, by the way. And so I threatened the tenant, saying that, if you don't leave, we're going to the sheriff. And although they yelled and screamed, they were gone a day after they were supposed to. The buyer was able to do a home inspection to make sure they didn't damage the place, and both deals closed. But you see, it's more work. And you see it's more work. That's why I said if you could get rid of the tenant in advance, you eliminate a lot of these aggravation. And now I have a trick, which I'll tell you. I couldn't write it down because it's not legal. But I advise you. So let's say you have a seller that calls you up with something like this and says, I have a tenant and I want to sell and I can't evict. What do I do? So you tell the seller to go sit down with the tenant themselves and have the following conversation. So what they're going to say to this tenant is, look, your lease has come to an end and we've decided to sell the property. And because you've been a good tenant, we'd like to offer it to you first. Do you think that you would be able to get a mortgage because we sort of know what the house is worth, and in this way we could avoid real estate agents will just sell you the property. 99 times out of 100, the tenant says, I can't afford it. But they'll appreciate that. And then the owner will say, I'm sorry to hear that, we don't want to do anything that will inconvenience you. So how long do you need to find another place? Do you need 60 days? Do you need 90 days? We're not going to call a realtor until you found another place. Now, I'm stopping there. Does that sound like a nice conversation?
Yes.
It's completely illegal. Because the tenant doesn't have to go anywhere. But let's say he left. Let's say 90 days later, he left, and your owner decided, I'm going to fix this place up and rent it for triple the rent. And they did that. Could the tenant sue them? The answer is no, because they didn't give any notice. You see, had they given the family notice and not gone in, then there's no notice here. Would you like to go? They left.
You mean there was no notice given by this?
The landlord hasn't given any notice. He just said, we don't want to do anything until you leave, and they leave.
So it's actually negative if you give the actual notice.
No, you can't. You can't. You can't give a notice because there is no notice. You can't give any notice before you put a property up for sale. There's no notice that it's legal. I know that you've done it. They're not legal, those notices. I laugh when people call me and they say, the landlord sent me the notice, you must leave. By the end of May, we're putting the house up for sale. I say, you don't have to leave. That's not a legal notice. Just so you know, it's not a legal notice. So you'll learn something here today. But you may come to a situation like somebody mentioned earlier. The tenant has a lease until December 31st, and the buyer wants a vacant possession end of June. And they're offering you a ton of money for this property. So the only way to do it is you put a conditional on landlord or seller obtaining the agreement of the tenant to leave earlier, and then go make a deal. And if it's worth a lot of money, pay them money and arrange the termination. But that's the only way you could do it. It would have to be conditional on the tenant agreeing to leave early. That means you'd have to pay them some money to make them go away. Okay, so did you learn something there today? Okay, so I wanted to, first of all, a couple of things. Again, if anybody wants to pick up my guide, it's just $20. It's really worth it. And if you don't have cash, I brought my little debit machine in case you have Visa. If you're not on my mailing list, then just give me a business card and I'll put you on my email list so you'll get all my emails that come out. And I don't understand why your next deal is not coming to me. So you just have to remember that when you leave here. Okay, but are there any questions now before we do that?
The questions about the rates here, so this one here is $7.99. Is there an extra fee?
No, thank you. You'll see that it's actually $8.99 scratched out to $7.99. It includes the mobile signing. It includes it. Now, why do we take $100 off? I don't know if you do this, but the $100 is if the client does an online review. So if they do an online review of our service, they get $100. I don't know if you survey all your clients after closing. It's a really good thing to do. Because we learn what people want, how we can do things better. So we're working on an app now, I think, so that if you have a client with the firm, you can actually go into the app and see the status of the deal. So if you'll press a button, it'll say documents sent out to the other lawyer, signing appointment arranged. You will actually be able to see the deal because the agent said they might like that. And so what I would do is if for every deal that closes, if you're not doing it, this comes from, I think, my real estate salespeople, have somebody in the office call the client and do a very short survey, 2 questions. What did we do the best? Because then you have a testimonial. And 2, what could we have done better? Because that way you'll not be surprised in 6 months when somebody went to somebody else. And then you'll find out there was a misunderstanding. You can fix it. So I strongly recommend you do that. We actually take $100 off the price if the client does an online review because we learn from that. We think it's a smart thing to have. Yes?
In a totally different scenario, right? If both the tenants and landlords, for whatever reason, whether it's sale, private, personal, and would the N11 still apply without a compensation? That would be another problem.
So just for your understanding, an N11 is an agreement between a landlord and a tenant to end a tenancy earlier. So when I said make a deal with a tenant, let's say the tenant says, yeah, I'll leave at the end of April, you give me $5,000. So you get them to sign an N11 that says they're going to leave April 30th. And what I would do is say, we're going to pay the money to your lawyer, and when you're out, you collect the money from your lawyer. And that's how you do it. But so the N11 is sort of like the release form that says they're going to leave early. Now, in that example I gave you, where the landlord said to the tenant, how much time do you need to move? Somebody asked me, should we get the tenant to sign the N11? I said, the minute you put a form in front of their face, what are they going to do? They're going to ask somebody. I have this N11. And then if they ask any lawyer, the lawyer's going to say, why are you signing this? Well, they told me I have to leave at 9. Until you don't put any N11s in front of people's faces. Let them go. But if you're going to pay somebody money, then you need to sign the N11. But that's what you have to think about. You don't pay them the money until they're gone. Yes?
Just to clarify, that strategy, when you pay them using an 11, that happens during the currency of, let's say, a lease, or only a month-to-month?
Anytime, any lease. The only thing that's illegal is if you signed with the tenant today, let's say a 1-year lease ending next year at the end of April, and you said, let's sign an N11 that you'll leave at the end of April. That's not legal. It can only be signed during the lease term. Any other questions? Okay, let me just see this. Did I put anything else in here that I did not cover? Let me just see something. I just wanted to make sure I put everything in here. Let me just see something. Okay. I didn't cover the language here. Just look on. If you look at the last page, I talked about letting the seller stay after closing and being very careful about this. So what happened was, I just forgot the slide, but people came to me last summer in July. I still remember it. And they said, we closed our house at the end of April, and we needed to stay in the house till the end of August because our new house was not going to be available till August 10th. And the buyers agreed to let us stay till the end of August. I said, okay. Well, the builder has now sent us a letter that closing's been postponed till the middle of September, which happens a lot. And so they said, if we have to move at the end of August, store our furniture, stay in a hotel, it's going to cost us $10,000. So is there anything we can do? So I said, well, let me see the contract you signed. So they showed me the agreement they signed, the purchase agreement. And it said, right in it, seller agrees to lease back the property from the buyer for 4 months, ending August 31st, 2018. So I looked at it and I said, you're a tenant. And what happens to your lease after 4 months? What does it automatically become? Month to month. And for a tenant to terminate a monthly tenancy, how much notice do they have to give? 60 days. It was the middle of July. I said, send a letter to the seller saying we are now giving you our termination notice effective September 30th. So they said, the buyer's going to go crazy. They've made plans. I said, do you want to pay the extra $10,000 or not? So they sent it, and the buyer went crazy. And I said, tell the buyer to speak to their lawyer, and there was nothing they could do. And so I gave you some language to consider here in your little handout, and let's just go through it. The parties agree that the seller can remain on the property after closing as a licensee only, under a license to occupy for a period not to exceed, you could put 30, 60, 90 days, and the seller will have no rights as a tenant under the Residential Tenancies Act. So you see, if that language was in their agreement, then the buyer could have shown up on August 31st and changed the locks. Do you understand? That's the reason I have that. So please, where possible, don't let this happen. Don't let sellers stay. Don't ever let buyers go in before closing. I never understand that because they're just going to look for problems in the house and raise them before closing. So, but if you have to do it, consider that kind of language. Okay? So any final questions? Okay, so is there anything you wanted to say to everybody?
Appreciate you joining us this morning. Turn your phones back on. I think we've had some product to sell. Thank you.
Thank you very much.